Well, everyone, thank you so very much for joining ZL Technologies, BDO, and Intel as we present today's GDPR is Coming. Don't be left in the dark. Our speakers are Dan Christensen. He's an attorney with Intel Corporation. So Dan, would you please go ahead and introduce yourself and tell us a little bit about you?
Sure. Thank you, Linda. I serve currently as Group Counsel of IT, Privacy, and Security in the new Chief Data Office at Intel Corporation. From 2010 to 2012, I was also seconded from Intel to serve as Chief Privacy Officer and Assistant General Counsel for a large private equity consortium of healthcare, finance, and technology businesses in Los Angeles. But primarily, my career has been at Intel over the last 17 years, providing legal support across several industries in telecom technology and healthcare, also being sent to Europe, Russia, Middle East, and Africa for 3 years to hire and lead a legal support team of transactional IP attorneys supporting the business efforts in those regions as well.
Well, thank you. That sounds pretty exciting. Some great trips. The next speaker that we have today is Jim Koziel, and he is with us from BDO. So Jim, please go ahead and introduce yourself.
Thanks, Linda, and thanks, Dan. Again, so for those of you who don't know me, my name is Jim Koziel. I'm a director in the Technology and Business Transformation Services group at BDO. So we are an advisory practice. I'm a client-facing consultant. Been in the industry for, 25 years or so. Started out on the IT side, focused on email and kind of messaging communications. And I guess if the table had kind of three sides to it, I've kind of spent time on three sides of the table around being kind of the customer and kind of the buyer of, solutions and services and whatnot. I've also been on the vendor side, providing solutions to organizations, and then on the consulting side as well. And here at BDO, kind of cross industry, a lot of focus on financial services, on, healthcare, but, across, manufacturing, nonprofit, et cetera. So our practice provides, information governance services, where GDPR certainly comes up, very frequently, along with data privacy, cybersecurity, litigation readiness, e-discovery. So certainly looking forward to the conversation today.
Thank you. And lastly, you guys, I'm Linda Sharp. I'm Associate General Counsel here at ZL Technologies. A little bit about myself. I've been in the industry very similar to Jim, way too long. I started in the industry about 1978 as a paralegal and then worked in the technology space as I attended law school and ultimately did consulting in the e-discovery space for about 10 years and then joined ZL, recognizing there just had to be a better way to do this. So I joined ZL about 6 years ago. So today what we're going to discuss is the GDPR issues as well as a little bit around Privacy Shield too. So let's kind of talk about, where our agenda is for today. So what is GDPR? Who is impacted by the regulation? What should organizations be focused on? And then key considerations and next steps. And then lastly, although it has questions listed, please, if you have questions, feel free to go ahead and ask those throughout this seminar today. So first off, what is GDPR? For those of you that are not familiar with the verbiage, basically it's the General Data Protection Regulations that came out of the EU. They actually go into effect on May 25th of 2018. However, did somebody say something? I'm sorry. So anyway, however, even though those don't go into effect until May 25th, the reality of it is that today, if we're not already taking a look at what we're going to do to be prepared, we're probably already behind the 8 ball. So a lot of organizations literally started this initiative even as far back as when Privacy Shield went into effect in February of 2016, because they're going to kind of dovetail each other. So GDPR is not only a general set of rules to protect data privacy and security, but it's an impact at a global level. So effectively, any organization that has employees or in any way does business with Europe, GDPR would in fact be invoked. So Dan, why don't you go and share with us a little bit about the history and kind of how we got to GDPR, if you could.
Sure. So GDPR is in response to changes that they felt that in the EU needed to be made from the 95 EU directive that had initially established a stake in the ground on data protection in the EU. So it's in response to that 95 directive that we have some key changes that are listed here out on the slide. A couple of them that just of note, and you'll feel more of this and hear more about this as we go through this slide presentation today. The biggest changes are one of them is accountability. Companies will need to be able to document and demonstrate their capacity to comply with GDPR requirements upon request or in response to individual data subject request rights, to exercise their individual rights to access portability for erasure, rectification, and so forth, for example, that those types of things weren't in the original 95 directive. Some other things are the expanded definition of personal data. The 95 directive, contemplated a world in 1995 that was a little different than 2018, 2017. And so the new GDPR Article 4 Sub 1 definition of personal data now includes things like location data, online identifiers, genetic material, biometrics, facial recognition, some other things that were not really as prevalent in 95 when the 95 EU Directive Article 2A definition of personal data was established. Also records. Article 30 of the GDPR is a very short provision. It's a very interesting one, especially for companies like ZL Tech and BDO. But it really is the Bible, so to speak, if you talk about the importance of personal record keeping, or personal data record keeping and processing. Article 30 requires record keeping, or as we like to refer to it over in the US, data logging or mapping of the processing activity. And the way it's worded almost requires entities to take more accountability of their data. In other words, to know where their data is on their systems. And that's in reaction to the types of spamming activities and other things that the world has undergone in the last 20 to 30 years. Another couple of just points: increased liability for processors. For those of you in the HIPAA world, you'll know how HIPAA has changed to make more liability for business associates as opposed to covered entities. Sorry if you don't know HIPAA very well, but covered entities, those hospitals and other units, were always imbued with all the liability, and now the HIPAA amendments have required business associates, kind of those outsiders, to increase their liability. The same thing is probably true in a similar way to GDPR with respect to data processors. No longer are the data controllers just the ones that are required to have the liability. It's now data processors, those that process data for the controllers, that now have to be imbued with that, or endowed with a lot more liability. A couple other points: strengthened individual rights I talked about earlier. Data subject rights of rectification, deletion. People can ask for their data right away. I want to know exactly what a company like Intel or someone else holds about me, and have it given to them in a certain period of time. Breach. A breach notification within 72 hours. The 95 EU directive never even talked about breach. Now you have an entire article dedicated to, a couple of articles, 33, 34, and 55 talk about breach notification to regulators. In 33, Article 34 talks about breach notification to the potential victims, the individuals. And then 55 tells you how to go about the notification, and it has to be done to regulators, notification of a breach within 72 hours. Unheard of. Data protection officer, two more quick points of change. Data protection officer appointments. Unheard of before. Now you need an officer, someone that can be someone of authority that you can look to in the EU to be able to manage these affairs. And lastly, probably the clincher that everybody's most worried about: fines of up to 4% of worldwide annual turnover or revenue. That's not profits, and you can't throw it on your least productive or least profitable subsidiary. No, that's your worldwide annual revenue of your parent company. So 4%, up to 4%, is a massive number for a lot of big companies. Linda?
Yep, so thank you. So let's talk for just a second here, right? So we have Privacy Shield that's already in place, and how in the world do we get Privacy Shield, right? So we all know in October 2015, the EU struck down, based on Trump, struck down the safe harbor provisions. And then for a while there, we had nothing in play, right? It was kind of a limbo land. And then in February of 2016, the EU Privacy Shield requirements came into play. So it's interesting to me because a lot of organizations are so focused on the penalties around GDPR that a lot of them haven't really recognized that there are currently in place under Privacy Shield alone, significant penalties. So anywhere from as much as, $40,000 a day and penalties for failure to comply. And it's interesting because everybody is so heavily focused on GDPR, and I think a lot of times we're kind of forgetting that Privacy Shield is still out there and still holds us accountable for managing this information that's coming in from the EU. So where does that apply? Are you participating in decisions around managing multinational data? So within your organization, are you part of that decision-making process? So are you part of the individuals that have to identify where that data is located, what you're doing with it, how you're handling that information? And also, too, one of the things that Dan just hit on is processor versus controller. So that's another big area that we've seen a tremendous change. So previously, you could actually negotiate, let's say you're a company that's a processor, and you could actually, within your contracts, negotiate all liability back to the controller. So for example, if something were to occur and it turned out that EU data was inside the environment as a processor, you could actually make it such that contractually the controller was ultimately responsible. And that's one of the things that GDPR, as Dan just pointed out, really changed. So now all of a sudden, it's joint and several liability. So now you have as much liability as the controller does as a processor, and you may not even realize that you're processing and ingesting EU data. So as you look at your contracts and negotiating with other companies that you work with, you're going to have to make sure that you actually understand the kinds of data that you're taking into your environment as a processing organization. Are you a multinational organization? Basically, bottom line is a lot of times we talk to companies and they'll say, oh, well, we're not multinational. We don't have any employees in Europe. Okay, but do you do business in Europe? Does an European consumer have the ability to place an order, in which case you're tracking their information? That now may invoke GDPR for your organization or even Privacy Shield. Do you have employees with ties or relationships abroad? And then obviously we just talked a minute ago about the fact that October of 2015 is when Privacy Shield was ultimately struck down. So there's a lot of things that are happening, and we're kind of in a little quandary right now about what's really going to happen to Privacy Shield once GDPR takes effect. But the thing to kind of remember is that GDPR is a mechanism that gives us the right, the certification process, that gives us the right to have the information from Europe here in the United States. And there's a whole litany of requirements that come with that certification process. GDPR kind of adds more teeth to what happens if you don't properly comply. So let's go on to the next slide if we could. So who does it impact, right? So each organization anywhere in the world that manages or processes data about EU residents. Gentlemen, you want to talk about that just a little bit? Either one of you want to go first?
Sure, Linda, this is Jim. So again, I think you kind of mentioned it, right? So a lot of clients that haven't really gotten this on their radar yet, or not maybe taking it seriously, maybe think it doesn't apply to them, right? And your example was spot on, right? So if you've got a website and you have clients in the EU and you're capturing their data, there are considerations, for you to take there. So that's kind of really the first point I would want to throw out there.
Dan, did you want to add anything to that?
No, it's a great point that Jim makes. The nexus to the EU is going to be something people try to hide behind, and any nexus, I mean, literally any nexus is going to get you into trouble if you try to hide behind it. If you have any nexus to that EU resident data under a very expansive personal data Article 4 sub 1, you're going to be, the EU is going to put their hands out and say, what you're doing business here with somebody's residence EU data. And so I think Jim hit on a really important one, a website that's seen worldwide, and the EU simply says, yeah, you're selling product, you're marketing here, there you go.
Yeah.
So that's kind of scary, right? If you think about it, you could have a small mom and pop shop just trying to make a living, working out of their garage, and now they're either advertising or in some way reaching out to EU consumers. They may now be tagged for GDPR and have absolutely no idea it applies to them. So that's, getting back to the draconian nature, it's scary, right?
Yeah, and I think without going through every line item, I think the other one that really jumps out is the date, right? So the May 25th, everyone is typically deadline driven, and having that, on your calendar circled in red, trying to figure out what you need to do to comply there. And Linda, to your point, I mean, there's organizations that have been looking at this for a long time, large organizations, multinational organizations that have, multiple people, multiple tracks of projects trying to get their arms around this. But if you haven't, to the point is really now is the time, right? There is, the clock is ticking. So that's where, having these types of conversations just helps people understand kind of the sense of urgency, because getting your arms around this, and especially on a larger organization, not a trivial exercise, can certainly take some time.
Absolutely. So let's talk again too a little about what it says. What is the personal data, right? So under Article 4, it gives us this definition: any information relating to an identified or identifiable natural person, obviously an individual, not a corporation, who can be identified directly or indirectly by reference to an identifier. Dan, can you share with us, what the list is that actually applies to personal data? We know obviously at first blush, we think it's your social security number, your credit card number, but GDPR doesn't stop there, does it?
No, it doesn't. In fact, the full definition includes, any natural person in one who can be identified directly or indirectly, is included, in particular by reference to an identifier such as a name, an identification number, location data, so a GPS data, an IPS or an IP number, an online identifier, so your computer numbers that are generated randomly, your license plate number, or to any one or more factors specific, quote, to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person, unquote. So amazingly expansive. They're trying to, encapsulate any possible way that someone can spam, find a way to not adhere to the right to be forgotten of a potential EU citizen.
So the amazing thing is going to be, how in the world are we going to comply, right? And that's one of the things I think a lot of organizations today are really struggling with is, my goodness, how, I can imagine a company as large as Intel or some of the other, very, very large organizations out there with hundreds of thousands of employees. And it's not only the consumer-based data, but it's their employee-based data as well, right? Information they've been tracking about their own employees. So where is GDPR going to be enforced? So although it's an EU regulation, organizations in the US and globally are potentially impacted, right? So as we look at GDPR, there's registration requirements. What do we have to do here in the US to make sure that we're compliant? Or what are our ramifications here in the US?
I think, one thing, and we'll talk about this in further slides. I think in a couple of slides, I'll talk about some of the things you can do to prepare via work streams and other things like that. So I'll wait on that one. But one thing, the main thing I think you need to do is pick a lead regulator. The EU is not going to require you to choose all 28 countries and therefore be exposed to Germans, Italians, Spanish, every single regulator, every single time there's a potential audit or regulation problem that you have. So as we talk today, Jim's going to go through a number of slides. Linda, you're going to talk about some things. I'm going to talk about some preparation steps you can make through data mapping and other work streams. I think the important thing to do is just know that you just need one lead regulator. Intel's choosing Ireland, for example. We've got a factory with 5,000 people there. We have a nexus there and some goodwill, I guess. So choosing a regulator is really important. I won't overdo it right here, but having a good connection with the regulator. I know there's some regulators. I love the Italians and the Spanish, but traditionally they've been a little more, hard-lined when it comes to regulatory fines and things like that than say the Irish have. So we're choosing Ireland. They're more like, they're going to give us credit for trying. And so I think it's really important to choose your lead regulator very carefully, because once you establish that relationship, they will work with you on proactive approaches to your compliance with GDPR and reactive approaches when something goes wrong.
Excellent. So we're going to hear a little bit more about that in just a few minutes, right? So that kind of gets back to also your slide earlier about if you have a breach and you have to provide notice within 72 hours. How in the world would we ever be able to do that, right? Unless you have some kind of a relationship with the appropriate regulator so that you can meet those requirements. So let's talk a little bit again about why in the world did they do this? Why is this in place now? What happened? What was the triggering event? Gentlemen, do you have anything you would like to posture on that?
Yeah, so for me, things like this, there's that triggering event, and maybe Equifax is a bad example, right? But you've got, all these data breaches that are in the news, and there's the cybersecurity part of it, there's the information security part of it, but there's the data privacy part of it as well, right? So helping organizations understand if they have that breach, what is the impact? What data was released? Who needs to be notified? So for me, I mean, Dan, you probably certainly opine on this, there's probably other ones, but just understanding, the impact of, that type of an event, and to the extent that you can, plan for it beforehand, I think is certainly important.
And I just add, yeah, just so we can move forward, I would just add to what Jim said, because I think he's absolutely spot on. The spamming, everything, to the EU, who really believe they learned something from the World War II dossiers and the things that happened over there, with the tragedies of the Jewish population and others, et cetera. They feel like, culturally, the rest of the world maybe didn't learn what they learned the hard way. And so in some ways, this is very cultural, very reactive to the spamming and the mining and the data breaches that Jim talked about. And I think this is the first time that I've seen a major piece of regulation being led by lawmakers and lawyers and not by technologists. Traditionally, you have the internet being built, and then all of a sudden lawmakers, 5 years later, are cobbling together regulations to catch up to the internet. This time you've got a GDPR utopian statute that says, we want you to build technology in data mapping and other things like ZLTech and other, BDO and other groups are doing to build up to this utopian standard that I don't think anybody can 100% comply to, but that's just me.
Excellent. So I have to tell you, I had the opportunity on a flight not too terribly long ago to see the movie Snowden. So if any of you have not seen Snowden, it was a huge eye opener for me, and kind of it resonated to me as to why the EU, obviously to Dan's point too, because it's part of their culture, right? But why in the world the EU would be so concerned about that data being here in the US. So if you haven't seen it, I invite you to see the movie. It was shocking to me to see some of the things that our US government was doing to both US data as well as data abroad. So let's go ahead and move on to the next slide. So the next one we have here, I think, Jim, we were going to have you talk a little bit about data mapping.
Yeah, thanks. And we're certainly going to get into this in more detail. I think data mapping, it's a key component to your kind of GDPR readiness program. And for those that maybe haven't come across it before, and there's certainly different definitions and kind of different levels of detail that you can go into, but really it is just kind of understanding, where your data is, who has access to it, and also kind of where it's moving throughout the organization, right? So you kind of take a step back and think about, why do you even have the information in the first place, right? So, and that kind of goes back to your retention policy, how quickly can you get rid of information? What do you need to keep, what are you legally obligated to retain for a certain period of time? Then there's kind of the legal hold implications, if you have active litigation, you want to make sure you're not deleting anything and kind of suspending your purges. So then, how do you reduce the risk associated with all that data, and then kind of, fold in GDPR, data privacy, cybersecurity along with it? And there really are, multiple approaches. It kind of boils down to reactive versus proactive. We'll go into it in more detail in a few slides, but the short story is, again, you want to be ahead of the curve. You want to understand where your data is, who has access to it, what's eligible for deletion, what you can get rid of today, what you can get rid of tomorrow, so that you're not in a situation where if there is an event that does occur, that you're scrambling, kind of after the fact.
Thank you. So Dan, let me go ahead and turn this slide on over to you. So what should organizations focus on today?
Yeah, so I think the first thing you need to do is exactly what Jim just talked about, and what you were talking about, Linda, is the data mapping exercise. And this is where you need to find, good partners, companies that know how to do this. It's solution based. You can't do it on your own anymore. It's not, the days of papyrus scrolls and just getting your Iron Mountain, cartons and boxes together are over. In a digital world, you need to find someone who, or groups of consultants and others that can help you, depending on the size of your organization, to help you with the data mapping exercise. And for some organizations, like Intel and others, you might have upwards of 200 petabytes of data. lying around, when 1 petabyte of data is like listening to your favorite song for 2,000 years straight, the data footprint. So 200 petabytes of data growing at 50% per year, you've got a lot of rot there, a lot of redundant kind of data, obsolete, trivial data that we'll talk about. You need to find a way to map that and organize it. And that will be an ongoing exercise for the rest of time. And so getting that in place and at least getting it started to orchestrate that under Article 30 of the GDPR, so you have some accountability for your data. It no longer can be that you can say, well, 80% of the data that we have, we just don't know what it is anymore. And somebody then in Europe makes a data subject request and says, I'm leaving the company, I want to know what data you hold on me. And 90 days later or 150 days later, you return about 30% of it. Those days are over. And so you need a data mapping exercise that starts and gets a little more accurate over time. The second kind of area then is to figure out what your gap analysis is. Where in the GDPR are you deficient? And I think that's where the way Intel's doing it is we've developed some work streams, and you can go out and you can find on the internet, or you can look at, say, Nimity, some other tools that are available for the privacy professionals in your organization as you have them, or consultants if you need them. You can look to Nimity or Data Guidance or other companies have these preset kind of work streams. We've developed our own, and I'll just throw out the way we've organized ours. Use your own system. We developed 9 work streams that we felt captured the right buckets. And without spending too much time on, I'm not going to go into each one of them. Be 3 hours on its own. But each work stream then has, milestones and deliverables in each one. And I'll just read the titles so that you get an idea of what work streams we're looking at and what most companies look at to try to figure out where their gaps are in GDPR compliance. Our first work stream is governance and oversight. These things might include e-discovery. Where are you in your legal holds and your e-discovery? Law enforcement disclosures. How do you work with the FBI? How do you work with CIA? How do you work with Interpol? What are you going to do when they come and ask you for things? What are you going to do when you get a subpoena? Other things like DPO, your data protection officer. Who are you going to choose? Where are you going to put that person? The lead authority, as I was talking about with Ireland. Who are you going to choose to be your partner to help you with all of this as you go about that? Mergers and acquisitions, operationalization, and research practices. So that's governance and oversight work stream. I won't give you any sub-work streams for the other 8, but the other 8 include record keeping. We're talking about this data mapping, Article 30. Record keeping, your data accountability, your data expertise now that you need to develop. Third-party risk management. How do you work vis-a-vis your suppliers, and are they GDPR compliant? Because that is an article now in the GDPR. Are you choosing the right third parties? What about data transfers? You can't just move data from Europe into the US, even under Privacy Shield, and then quickly move it over into your Cayman Island data center, and then over into your Indian data center, and then over to Japan without some sort of data transfer strategy that's covered. Privacy impact assessments is another work stream. Data subject access rights, another data work stream. What are you going to do when somebody says, I want my data, all the data you have on me, and I want it in this amount of time, or I want you to rectify the hepatitis 3 false positive that you have that's disallowing me from giving blood anymore? How are you going to find that and correct it across your entire database within a reasonable period of time? Security management. Security is a big deal. You can't just encrypt everything and say you're done. Breach management, 72-hour turn, as we've been talking about. That's unbelievable. That's an unbelievably short period of time. And the last work stream, the 9th one, is training and communications. How are you going to get this out to your population? So once you've got those 9 work streams in place and you've divvied out responsibility to figure out the gaps in each one of those 9 areas, you develop what we're calling remediation plans. How do we remediate and up level all of those areas up to the GDPR standards under their respective articles, to the point where you can figure out the milestones and deliverables needed to, again, implement to the point where by May 25th, 2018, you can get as close to 90 to 100% as you can, but it's going to be hard to do. So that's kind of where we're at, Linda.
Excellent, thank you. So we did have a couple of quick questions that I wanted to go ahead and answer real quickly here. So one of the questions was, let me clarify this, does this impact EU residents, citizens, or both? One of you want to answer that?
Let me take that, and Jim can weigh in too. That's a really good question, something we've grappled with, because I was an expat to get an Oxford degree with Intel. Intel sent me over there to England for 3 years. So as part of the EU, well, Brexit aside, as part of the EU, I went over from 2003 to 2006 as an expat. Does that mean then that I'm an EU citizen or resident, or both, or neither? Because I'm an American expat to England going to Oxford. What about a German who comes with Intel and is sponsored to come over and expat in San Francisco in our offices over there for 5 years? Is that person then covered, and do we have to bring all this nomenclature and baggage with that person simply because we're moving him or her to the Bay Area for that period of time? And so it's interesting. I mean, it's important to look to the definitions, and the way the definitions say, they don't say citizen, they say EU resident is what the GDPR says. And so the way we've defined it as the people that are in the EU are cloaked with that account, their data is therefore cloaked with that the EU kind of GDPR coverage, I guess, if you will. I'm not so sure though we're not using that definition though to cover American expats over in the EU. But I think as a company, you're going to have to decide, where do you draw that line when you bring people over? Do they bring their citizenship with them? And therefore, are you going to have to use special databases or things for them when they're sitting in the Bay Area, or do you have them sign waivers and hope that works, or do you work it out with your lead authority? So I don't know. I'm interested in Jim's or Linda, your opinion on that.
Yeah, and I would just say, I mean, certainly I'm not a lawyer, but the conversations that we have both internally and with our clients, obviously leaning on outside counsel to understand, to your point, kind of which regulations are you looking at, which jurisdictions apply. And I think really it's just about being reasonable and documenting that and having that, so you can clearly have that definition within your organization. It may very well be different from one organization to the next, but if you're kind of thinking through those types of questions, that's going to position you pretty well for success.
So I like this question, guys, because you can hear how it's already creating debate, right? So one of the things I'm concerned about is so how do we define resident? GDPR doesn't define how they're classifying you as a resident, right? So at my previous employer, I was tasked with spending 6 months in a different state. So if you were to go to DMV and it says, if you are within our jurisdiction for 30 days, you must change your driver's license. Well, of course I didn't change my driver's license. I was going to be there for 6 months. So are you a resident or not a resident, right? So, and that's the other issue too. If we take a look at that, how we're going to classify that, I'm assuming that you would see for each country across Europe a very different definition about how they classify a resident. So how in the world are we supposed to figure this out when we don't really even know under GDPR how they have specifically defined it? And getting back to your point, Dan, right? So, I mean, did you change your passport? Did you change your residency status? Did you get a European, UK driver's license? All that stuff that you would normally do as a, quote, resident, right? And as we look at today, we have a very virtual world. Here at ZL, we have several employees that have come from other parts of the globe. Very, very common, obviously, in Silicon Valley. But I think that we're seeing that all across the board, not just here in the US, but we're seeing it overseas as well. So let's go ahead and move on to the next one. Okay, it's not letting me move the screen. Just give me 1 second. There we go. So Dan, share with us a little bit about the Zurich case. I would love to hear what happened.
Yeah, just for sake of time, I'll move pretty quickly, but it shows. This is going to show the drastic difference in fines between what's happened before May 25th and next year and what's going to happen after. If you look on this slide, this is an actual case where Zurich Group a group out of the UK, parent company Zurich UK. If you look at just a little bit to the left off center, Zurich UK, the data controller, and follow the arrows. I know it's a busy slide. This was a build, but we decided not to build it here just for sake of time. That they sent some outsourced data storage over to one of their subsidiaries in South Africa, Zurich, South Africa, which was a data processor of their own company. And so, but they had used, some lacked due diligence, and there was some compliance issues and over reliance on group practices that weren't exactly that well disciplined. And then they outsourced their physical data transfer of these storage files over to a third-party vendor in South Africa, a sub-processor, who then routinely transferred that data to a storage center in South Africa. The unencrypted backup disk was lost in transit. There was a breach, and about, I think it was 46,000 personal records, including bank account and financial information, addresses, insurable assets were breached and discovered by others and posted on the internet, whatnot. It resulted, because of these lapses across the board in this transfer of these 46,000 records, in a UK financial services authority, this is again pre-GDPR, investigating these transfers and issuing a £3.35 million fine. Now, the point of this case study is, had this been under GDPR, just this same set of facts, this same Zurich UK company that makes, a good, I don't know what their market cap is, let's say it's $1 billion a year. That billion a year could result, if it were a billion a year, maybe it would result in the same or similar 4% global revenue fine. But let's say it's a company like Intel that makes 60 to 70 billion a year. That fine, all of a sudden becomes a lot greater. And so you can see how the 4% global revenue fine, actually, if Zurich UK has $1 billion, then all of a sudden that fine, 4% becomes a lot worse. And so I think the point of it is now you're not held just to a UK kind of fine, a localized fine. You're now looking at a 4%, massive fine under the GDPR.
So one of the things I think is important about this particular study is we see a lot of organizations, they go out and buy up a lot of other different companies, and we kind of let them run their own, right? We have a very hands-off approach. They have their own IT department, they have their own accounting department, they have their own policies, right? So now all of a sudden, an event that occurs at one of those little subsidiaries could significantly impact the entire organization, because that 4% is based upon the entire organization's global revenue, not just the revenue from that little subsidiary. So that's one of the things I think companies need to start looking at is, how do we deal with our subsidiaries as we look at transfers of data mechanisms, as well as just what they're doing on a day-to-day basis and managing information that may invoke GDPR. So Dan, let me have you go ahead and start with this next slide.
Yeah, okay, so this is just kind of a reiteration of GDPR, compliance requirements and Intel's business strategy itself makes our ability to demonstrate compliance all the more imperative. We'll need to drive more effective data governance for everyone's company needs to leverage, established data office productivity, both with your IT departments to drive compliance, reduce risk, but also to leverage the value of data in a compliant fashion. GDPR significantly increases the penalties for failing to comply, and this affects companies that process data on their own behalf, and also for those who process data for others. And so for you companies like Intel that does both, controls data and processes data, we're getting, kind of the double whammy, and you need to be aware of that as you go forward towards GDPR compliance.
Thank you. So Jim, share with us a little bit, so what kind of controls do we need to put in? What do we need to be doing?
Thanks, Linda. Yeah, so we borrowed this slide from another piece of collateral, but the short story is here, right? So from a discovery perspective, we've kind of talked about it already, understanding where you have, what you have, where the sensitive information is, where the PII, PCI, PHI, what the retention should be, where the applications are. Is it on-premise? Is it in the cloud? Is it on a desktop, on a laptop? So just that data discovery, that data mapping that we've talked about for a while, organizations have different levels of maturity, and they're also very ingenious to some extent around maybe repurposing existing tools or, trying to figure out the best way to kind of address this, right? So I've got clients that they've gone out and, purchased specific tools to understand where their data is, but they also leverage tools that they might already have, today, maybe for something different, right? So we have organizations that are using applications like for their help desk tracking or their software asset management tracking and using that as a starting point. One of my clients had over 600 applications, global organization, and they used their, kind of help desk ticketing system to say, okay, these are the 600 applications we're getting tickets on, and then kind of drilling down on that from there. So there's definitely that. There's the discovery component, working with your legal team, your business and compliance folks, and mapping the flows of the data, not only, categorizing or listing, we've got 600 applications, but where do these applications touch each other? Who has access to the information? I think Dan made the point around partners, right? So from a supply chain perspective, are you, transferring data to the cloud where, maybe other partners may have access to it that you might not have been aware of? So documenting the data flow for key applications is certainly something that we're seeing in the marketplace. And then, figuring out, okay, this is what we have in our current state. Where do we need to go? Where do we need to get to, both for that, May 2018 deadline and beyond, to come up with that roadmap, that game plan, to see where the gaps are and to remediate them.
Let's go ahead and go to the next slide. I think this is also you, Jim. Let's see if I can get it to click.
Yeah.
There we go.
Yeah, so again, you don't want to necessarily take that boil the ocean approach, but where do you start, right? So it's really having conversations across, different stakeholders. We'll talk about, who those stakeholders might be, but really defining, what do you have documented from a business process perspective? What Visio diagrams do you have that kind of map out that data flow, especially for those, mission critical or, riskier applications? Looking at your applications inventory, maybe you have a software asset management system, maybe you don't, depending on the size of your organization. Maybe you have multiple systems that you need to kind of normalize and rationalize, to your point around subsidiaries, mergers and acquisitions, divestitures, all these different events that potentially impact all of this activity, right? So a lot of our clients, they're really just focusing on the sensitive data, and they're really looking at, we kind of talk about structured data and unstructured data, right? So for the structured data in the databases, in those Oracle, Excel, Oracle SQL environments, focusing on the structured because it's easier, right? But there's all this unstructured data that's out there, all the Word, Excel, PowerPoint, loose file shares. And organizations are struggling with that, not only from a GDPR perspective, but a broader kind of privacy information governance perspective. So looking at it holistically across the landscape of structured and unstructured, from the inception, from when you're creating the document all the way through when you're disposing of it, and then mapping that back to your retention schedules, the different data types, departments. So again, it can be very complex. Definitely organizations have different levels of maturity, but we're seeing some really great progress around people kind of trying to take what they have, leveraging that for GDPR, identifying the gaps, and then trying to fill in the blanks. Right.
If we talk a bit more about mapping, I don't know if you want to add a little bit more to this, if you could.
Yeah, there's definitely more slides on it. I think just to kind of go through, why it's important. Again, the regulations, especially my financial services clients, have gotten ahead of this to some extent. The explosion of the data growth, I think everyone's kind of seen all the statistics around, the new volumes of data that get produced on a daily basis. We've got some clients that are starting to look at, the Internet of Things and all the data that gets generated from all these new devices that weren't in play just a few years ago. Talking about, where data is located, right? So before it was, maybe in a data center that you controlled, or on your desktop or your laptop or your file server. And it's a different paradigm now, right? So you've got the cloud, you've got different, models. You've got data in different countries, right? So, and the implications of that, and to kind of align that with the risk appetite that your organization has that you're looking to accept, understanding the value of that information, right? We talked about, redundant, obsolete, trivial, and the statistics around what percentage of your data is actually useful. And the fact that we have clients that are seeing, 70% of their data being, that rot category where they can potentially get rid of it. And just the less you have, the better off you're going to be, just from a management perspective. Not only the cost of the storage, which you may have already paid for, but just the risk associated with keeping things forever. So we have all sorts of conversations with our clients around that. Again, kind of talked about that information sharing with partners, third parties, the whole supply chain, and how that impacts around social networking, mobility access, what data ends up on your cell phone, and the impact of that. And again, Equifax, Sony, pick a company that's been in the news around all these data breaches, the impacts of that data loss. And to your point, the 4% fine that's out there, you don't want to be the next person that's on the cover page of the Wall Street Journal.
And so I think one of the big issues, right, is we just keep too much, right? We're not getting rid of anything. All we do is just try to find, cheaper storage, right? Let's push it here because it's cheaper. And the reality of it is that we need to be looking at is, cleaning this stuff up. It's kind of like as you look at your garage, and when your car's out on the street because there's no room in the garage, you got too much stuff in there, it's time to clean it up. Get the car back in the garage where it belongs.
Yep.
So here's a data mapping process. Jim, you want to walk us through this?
Yeah, and I'm going to go quickly. I think, from a process perspective, it really is just good to kind of take a step back and put your thoughts on paper and understand where you are and where you need to go. So I'm not going to necessarily go through, box by box, but you really want to understand who your stakeholders are, what their roles and responsibilities are, where the data is, where the vital records are, aligning that back to retention, and then just, building this out and coming up with a repeatable process where you can clearly understand, who has access to what. And you're going to use that not only for GDPR specific information, but, broader, data privacy, information security, cybersecurity, litigation readiness, e-discovery. So all this process, it not only will help you with GDPR, but it will help you with other things as well. So one of the things we get asked a lot from our clients is, okay, where do you start, right? So I kind of broke it down into 4 buckets here, and really there's these different approaches, right? So talking to people within the organization might sound simple, but it's a great starting point, right? So getting people on the phone, getting people in a room. We've had great success with just getting people in front of a whiteboard and starting with one application, looking at your desktop or your laptop and looking at the applications that are installed, right? And then trying to map through the ones that you're familiar with on a whiteboard. You take a picture of it, you get somebody to put it into Visio, you've got kind of a level 1, very basic data map, right? So there's the interview-driven approach, just talking to your colleagues and kind of doing that, right? So then you've got the existing technology, like I mentioned, clients that are using, software asset management tools or other tools that they may already, have within the organization. So they're not necessarily making purchases aligned with this, but they're kind of using what they have, using that information to build out their GDPR readiness strategy. And then in certain situations, even if you have existing tools, there may be new tools in the market that can help you accelerate some of this, right? So understanding where your unstructured data is, where your structured data is, mapping that out. So we've certainly got clients that are looking at technology solutions in this space. Dan mentioned some earlier, to kind of accelerate this process. And then, finally, we've got scenarios where people have made significant investments on the backup side, right? So if they don't necessarily want to install a new software solution in a production environment, they're taking a step back and looking at what they're backing up and saying, okay, can I get some information from my backup environment around, where my data is, who has access to it, when the last time it was accessed, where is the PII, PCI, PHI? So kind of looking at it maybe a little bit differently, so they're not, having that impact on production, but still getting the same information that they might otherwise.
So as we do a quick recap, basically what we're talking about here is we have structured data and unstructured data stores, right? So understanding what technologies you have available in both, looking at your data map to identify what data is there, how can I minimize access to this information, but more importantly, how can I reduce that footprint? Because as Jim kind of pointed out, quite frankly, in some of these data breaches, if you don't have it, they can't get it. So it's going to help to reduce the risk that's associated to the organization by having information that is literally not viable to the organization anymore, or not good viable content. Aligning with and updating your policies. We are starting to see a lot of organizations today go back and revisit those 500-page, records retention plans, right? And going with more of a big bucket approach, something that employees that can actually take a look very quickly and identify where a document belongs instead of spending hours trying to figure out what key it goes under. Other organizations are actually using GDPR as an opportunity to create a defensible deletion policy. If I can reduce the footprint of information that I have to search through in the event of a subject access request, I'm going to make it much more effective to be able to find the information I'm trying to find. If I'm looking through, hundreds of petabytes of data, and the time that it would take to actually find, somebody's social or even just their email address or their name, and searching across all that information to make sure that you've actually located and be able to produce that information to the individual requesting, or more importantly, how do you remediate that when there's so much data out there? So the more that we can reduce that footprint, the better off everybody's going to be. And then importantly, I think it's combining data privacy, data security, e-discovery, the records teams. Everybody needs to be engaged to understand what this initiative needs to be, so that you know how we're going to find and get to this information and set up defensible processes within your organization. So Dan, can you tell us just a second here a little bit about some of the testing that you guys do, or what you're seeing other companies do to make sure that you're ready when that first SAR request comes in? I hate to put you on the spot.
Yeah, sure. No, there's a lot of internal penetration testing going on, and although I couldn't speak, with technical savvy like Jim or yourself could, I know that the testing, you need to test those systems. You need to be ready for, what's going to happen when a request comes across. And part of our work stream effort on governance and oversight is ultimately going to be more and more of that. Take a few scenarios, data subject right, for example. What happens if someone comes and says, I want to rectify the data? I gave an example earlier. A problem we had a couple of years ago is Intel started putting health centers across all of our, major campuses, so that people could get, not only gym time in, but also get, shots if they needed to go to South Africa on a humanitarian effort, or whatever, done from doctors and nurses just right on site. Well, that created a host of problems, because when you give blood, for example, at an on-site health center, and the blood type is a false positive, like for myself, I'm O negative, I love to give blood. If I got a false positive and it's replicated across Intel's 59 data centers, and then I want to rectify that data, how do I do that if 80% of Intel's data, we don't know where it is, or we have no accountability over it? So that one particular scenario, you need to penetration test. You need to figure out, okay, if someone comes from the EU and says, I have a false positive, hepatitis C or whatever, in a blood draw that I gave, and I have 3 now doctor letters right here saying they've taken my blood and I am not hepatitis C. I want to start giving blood again, and nobody will touch me with a 10-foot pole because of your false positive. I want my data corrected right now. Under the GDPR, and they start quoting articles to you. You only have a few days to correct it. What are you going to do under that instance? And you need to be able to go across your data and correct that data to the point where, ARUP and Red Cross and other international organizations even aren't going to start turning that person away. And that's just one small corner case of the myriad things we're going to have to be able to do to be able to comply with GDPR. If that EU citizen or resident keeps getting false positive notices back, they're going to make a complaint, and it's very easy to make a complaint under the GDPR now.
And let's add to that, right? I mean, it doesn't even have to be, something where they want data, something like that out, right? All they have to do is say, I want to be forgotten. I just want you to take this information out of there. Right? They don't. It's so broad in what they can request us to have to do to be able to remove their information. And again, getting back to, if we don't clean up our data stores, we're never going to be able to meet this obligation. We have to get this stuff cleaned up. So Dan, let's go ahead and move on. I think actually this is Jim's slide. So Jim, you want to share a little bit more with us about policy assessment and development?
Yep, and I'm conscious of the time. We'll go quickly here. Again, I think we just want to make sure that folks really treat this as it's more than a project. It's probably a program in most organizations. And we talked about, aligning with policies, and the outside counsel folks that I've talked to are definitely focused on this to make sure that, the policy that you have documented, especially your retention policy, that you're adhering to it, right? Because if you're not adhering to it, there's potential implications to that. So, we're certainly seeing opportunities to help clients streamline their policies, update them, have a process where that is, periodically reviewed. So it's not something that just sits on a shelf, is not looked at, and then you've got the risk associated with that, right? So Dan mentioned kind of who you're going to follow, right? So there's all different authorities that we are looking at from a data privacy, information governance perspective, mapping back to those different authority documents to make sure that, all the different considerations are out there. And there may be situations where the regulations are different, right? So to call those out and to have discussions around, if one regulation says something totally opposite of the other, what are you going to do in that type of scenario? A key consideration is around who is impacted and what lines of business within an organization do you need to talk to, right? So certainly legal, compliance, information management, technology, but there are other folks that ultimately you want to talk to as well, whether it's having interviews with them or doing a questionnaire or having other tools that might look at those types of applications, which is clearly understanding the key stakeholders. And it's certainly a broad list. I'm on a project right now. We're talking to upwards of 30 people in the organization in these types of departments to get that feel for where to start. Talked about aligning with standards, talking about policy assessment. But again, the short story is to come up with the program, having the process in place, assigning dedicated resources to help with this, working with technology to position you for that May 2018 deadline.
Excellent, thank you. So I know we're at the top of the hour, so real quickly, give us, if you could please, 1 or 2 more minutes. So obviously one of the things that we learned from e-discovery is about 50 to 60% of data that we store in our environments is employee personal garbage. So basically reaching out and getting rid of that garbage, that's the stuff that's going to create risk when a SAR request comes in. It could be employee garbage. It could be an employee who refinanced their house and now their spouse's information is sitting in your data stores. So making sure that you understand what you have out there and how you can get it cleaned up. There was a recent study that just came out and indicated that, in fact, it's not 50 to 60%, but in fact, 85% of data stored is either dark or redundant, obsolete, or trivial data. So on identifying how we're going to get rid of this information so we're not subject to having to produce it under a GDPR request. So let's go ahead and take a look next at some key considerations. Thing to remember is one size doesn't fit all, right? You have to look at your organization, how you're going to work within your organization, what kind of data are you capturing, and what are you doing with that data. So GDPR is also going to be a moving target. It's subject to different national as well as EU interpretation. It can be, if you have data from Germany, it may be interpreted differently than if you have some data from Ireland. You're going to have to know how that affects your data stores. And privacy and maturity and awareness is it's inconsistent. So basically understanding how long have you had the information? What am I doing with this data? Why do we have the data in the first place? Company-wide changes may be necessary for compliance. Again, getting back to the example of those subsidiaries, where you may have an issue that that subsidiary has information or is doing something that may ultimately affect the entire organization and have absolutely no idea. So do you have a CIGO, a Chief Information Governance Officer, who's ultimately responsible for all subsidiaries' data and how they're handling and what they're doing with it? So that's an area that we're starting to see a lot of development, is literally organizations focusing on more of a CIGO role or a Chief Information Governance Officer type role. Lastly, next steps would be build a privacy shield and GDPR compliance program. Make sure that you have something that you're working on internally, understand and document where your data is located, review existing policies and procedures to determine if there's any updates that need to be required, what's your acceptable use policy, what's your data retention policy, and more importantly, do some testing. Put yourself to some, drills, pretend like, okay, I just got a SAR request in. What do we do? Who's our DPO? Where's the information? What kind of data are they looking for? Where would I find that information? Do we have logs of our training prove that our employees have gone through privacy and data security training? All of these things that you're gonna have to make sure that you have in place. And then importantly, and let's talk where appropriate. Talk to outside counsel, talk to vendors, talk to appropriate consultants. Look at new technologies. Just because you have had a particular technology in your organization and it's worked, it may not work going forward. So sometimes to put a Band-Aid on a solution may not be the right solution. Maybe you do need to look at new opportunities and new technologies to help you move forward in these requirements. So with that, I think we had one last question I did want to make sure and answer, and I know we went through these last few slides very quickly, but the one question is, are the slides going to be made available? So yes, they will be available later on this afternoon on the zlti.com website. So if any of you want to go out and download those, we invite you to go back through the material. I know some of it we covered very, very quickly. So gentlemen, I thank you so much for your time today on behalf of ZL Technologies, our folks over at BDO and Intel. Thank you for joining us today. And for everyone on the line, thank you so much and have a wonderful afternoon.